Good morning, good evening, good afternoon, I guess. I don't know when you're watching this. Time zones, how do they work? Happy New Year to everybody. I have had an opportunity to read the the appellate opinion in Earl David Worden's case. And it is as I expected. I gave odds of about a 20%-ish chance of success for Earl, just because it's such a disfavored motion. I thought his attorney on the appeal level, on the appellate level, did an excellent job. I thought the state did a poor job in defending the appeal, but they had the high ground. It's a disfavored appeal. It's hard to win on all of the issues. What the Court of Appeals essentially said was, yeah, there were issues, but some of them didn't rise to the level of actual harm. Oh, you didn't preserve this issue. Well, that's too bad. Oh, your attorney didn't preserve that issue for appeal. Well, that's too bad. But your attorney did a good enough job. Your attorney did a good enough job that it wasn't ineffective assistance of counsel. So what they're saying there is that, was it a perfect trial? No. Was it a perfectly fair trial? No. Was it a fair trial? They're not saying that. They're saying it was a fair enough trial. And that's really all you're entitled to in the U.S. And it makes sense on a lot of levels. It makes sense that, you have an attorney who's human. It's easy to Monday morning quarterback attorneys when you're not under the pressure they're under at trial to make timely objections and have all of the facts in their case present, know all of the pre-trial stuff, like what has been agreed to be excluded, what information the prosecution has shown you that they're going to use at trial. Is what they're talking about something that they've actually disclosed to you? I mean, there's so much in an attorney's head during a trial that we're human. You're not going to get perfection. The best attorney out there isn't going to do a perfect trial. Just like the best quarterback out there isn't going to do a perfect game. And our system needs a level of closure. Was it so egregious that you have to get a new trial? The Court of Appeals in this case said no, and I expected them to say no. I am honestly disappointed that they said no. And this is going to be an unpopular opinion on my channel, but having read the transcripts, having read all the appellate briefs, having read the motion for a new trial briefs, having listened to the oral argument on the motion for a new trial, having done all of that, I don't think that Earl did what he's accused of doing in this instance. There's too many issues that I am aware of. There is a massive issue in that the daughter's story changed. Now, it's a long time, and, people don't always remember their lies, and the truth changes over time. When you think about things, you're rebuilding things in your head when you remember things. It's not, and every time you access a memory, you change it. So, I mean, there's explanations for and against it, but either way, it leads to dubious testimony. When you add into that the issue that none of the other daughters who allegedly were going to testify that Earl allegedly molested them couldn't testify to any actual molestation. That's a problem. I mean, they testified to some things that were questionable, like Earl, with his wife present, allegedly talking to a daughter who didn't get allegedly molested about pleasuring herself with a Coca-Cola bottle. I mean, which would be sketchy as hell if it happened. But if he did it right there with his wife, maybe it's just an inartful birds and bees conversation. I don't know. I mean, but it's certainly not, one of these things is not like the other. Them talking about how she can pleasure herself is not the same thing as him actually sexually assaulting the other daughter. You know what I'm saying? They're different. There are a lot of issues, and there were a lot of things that I would like to have seen corrected. I think the court didn't think it was a big issue, but I think it was a big issue to have the lead investigator testify that he believed the witness. That was improper expert testimony. The attorney was late in objecting to it. I get it. But I think that people generally want to listen to an expert. And officers tend to carry a lot of weight generally, and lead investigator with umpteen years of experience investigating sexual assaults, believing the witness. I mean, the reality is that the sexual or the investigator believing the witness is kind of the baseline. If the witness has a credible enough story that it could possibly have happened, if he believes the witness, the victim, then the investigation will continue. If he can't believe the victim, the investigation most likely won't continue. So it's kind of a baseline. It's not really saying that the guy, that the alleged perpetrator did it. I mean, how many investigations go nowhere and they can't actually show? But I mean, the level of proof that they had daughters testifying that dad did other things, not sexual assault. The one victim, her story changed over time, and that's all the actual. So basically the only evidence that he did it was the word of the daughter versus his word that he didn't do it. And everybody else, all the other family members, other than, no other family member testified that they saw dad do it. No other family member testified to that. So you have the questionable testimony of the victim, because again, her story she made a report. There was a CPS report back in like the 90s, if I remember correctly, a long time ago. There was this, an investigation apparently was shelved where he allegedly groped her boobs, and it changed to the time of the trial from just boob groping. At the closest point to the actual alleged incident, it was boob groping. To at the time of trial, it was sexual assault with penetration almost every night for a year. Which would be horrible if it was true, but I have no reason to believe it is true. I have no reason. And I know this is an unpopular opinion. There are a couple different people out there who aren't being objective on this, in my opinion. And, do with this as you will. There's the people, the Schadenfreude people, who are just like, ha ha ha, Earl got his. I don't like Earl. I'm just happy he got his. And I mean, if that's your thing, just remember, you probably have people who don't like you too. And I wouldn't wish this on my enemies. But, you do you. You have your own morality. You get to account before whoever you believe in, whatever God you believe in or whatever. But, it's your morality. You get to do what you want. I don't really like that Schadenfreude thing. The other kind of person out there is a person who just believes the victim. And I would be hard pressed to think that if you didn't know Earl, if you didn't have a distaste for Earl, that you would. Now, you're going to say that 12 independent jurors came up with Earl did it. But remember, they were poisoned with the idea of Earl being racist, which has nothing to do with sexual assault. But evidence was introduced that he didn't want a mixed race child in his house. Evidence was introduced that he was a Mormon. Whether those two things are true or not, don't have any effect at all on whether or not he committed sexual assault. But it can poison jurors. If you have a negative conception of Mormons, it can have an effect on you. If you're a mixed race or racially sensitive person on the jury, it can negatively affect you. So if you just automatically believe cops, if you place great weight on the testimony of a cop that he believed the victim, maybe it'll have an effect on you. But just reading the transcript, just reading what the daughter said now compared to the 90s, it should place doubt in a reasonable juror's head. Again, that's my opinion. Obviously, a jury found him to be guilty, and that's that. But I'm not particularly satisfied with how fair the trial was. I understand that it doesn't rise legally to ineffective assistance of counsel. I understand that they didn't preserve certain issues for appeal. I understand those things. But at the same time, I'm not, I just hope we never experience this as a community again, where people get so agitated, both pro and against the auditors, where they go to a trial and they disrupt the trial. So, rant over. Thank you for watching. Make sure you like, comment, subscribe, click the join button, check out my PayPal, check out my Subscribe Star. Make sure to subscribe to me on Rumble, Odyssey, Twitter, or X, or whatever they call it, Facebook. Make sure you do all the things. Cash App's in the description. Have a great day.